There are conditions attached to it by the government, if nothing else, on how it is to be used, or accounts have to be submitted back, then that becomes something that the public can also access. So, but if you, for example, distribute diaries without specifying that this diary must only be used for official work, then that doesn't make you a public authority. But if you, for example, suppose you give land, you might not want accounts of the land, but you specify that this land is being given on the condition that it must be used for non-commercial purposes. Then the public has the right to know what you are doing. So I would define substantial not in terms of percentage, but if the input from public funds or public resources is such that there is answerability involved, then the public has right.
I can cite an example in this respect. We have the Cochin International Airport, which is being conducted by a society headed by the Chief Minister. Chief Minister is the Governing Council Chairman. But the government has only 26% share in it. The rest of the shares are held by private people. So we issued an order that this is a public authority, saying that this is headed by the Chief Minister, a number of ministers are in the Governing Council, the Chief Executive is appointed by the government, things like that. And the society went to the High Court under Article 226, but the High Court agreed with us. I just
Shall we? I'm sorry.
There's a synergy actually between 2F and 2H. Information says relating to any private body which can be accessed. So that point was made. That even if it is not accessed but can be accessed, it's covered. Now if you look at information, right to information, one is 2F, which says can be accessed. And if you look at J, held by, that is to say the information is already with, the private information is already with the public body. But the second part, under the control of. Right. So if you take the Minimum Wages Act analogy, I can ask for the minimum wages of workers in, say, Reliance Industries, because the minimum wages inspector under the Minimum Wages Act has the power, he has the control of that information. He can collect it. Education cases likewise. So held by means the public authority has got it. Under the control of means it is potentially available. So that ties in with information.
But the problem, Mr. Gonsalves, is that if somebody goes and asks the labor officer that please tell me in village X if Ram Hari Yadav is paying minimum wage to his servants in the field, right, should be now under the Right to Information Act that labor officer would visit the village, inspect the farm lands of Ram Hari Yadav and interview the individual workers and find out whether how much they are getting and then decide whether they are getting and then give this information.
No,
is that the postulate?
See, that's why
the law